Okay, right, we are going to now talk about engineering, contracts and law, right? The study objectives. I'm not really going to go through that, but let's touch on them. Okay, why do we touch on them? Just so that we can have a guideline. So yeah, here goes. After studying this, you should be able to, one, understand the basis behind the law of contract. Okay, list and explain the requirements for a valid contract, and then also apply the principles regarding offer and acceptance. Apply the principles that determine the presence or absence of consensus, and then evaluate the capacity of a party to enter into a contract. Okay, explain the principles relating to the interpretation of contracts. Explain the various terms that may be part of a contract. Okay, and then assess the consequences of breach of contract. Okay, and then explain the transfer and termination of rights. Okay, and then apply the principles of the law of contract to engineering, and to know the different parties traditionally associated with such contracts. Okay, and then yeah, so I'm just going to touch on 6.1. This is the introduction. So here goes. The South African legal system is founded on the Roman law, okay, common law, as well as Roman Dutch law. South African law of contract has developed from Roman law, which initially was concerned with a number of different types of contracts that developed to a general concept of contract through to Roman Dutch law, which treated every agreement made seriously and deliberately as a contract. Okay, so let's just read through that again. The South African legal system was founded on the Roman law, as well as common law, and then Roman Dutch law. Okay, so the legal system is founded on three things: Roman law, common law, and Roman Dutch law. Okay, the South African law of contract, meaning we are now referring to something specific. In this case, South African law of contract, it has developed from Roman law, okay, which initially was concerned with a number of different types of contracts that developed, okay, to a general concept of contract. And that happened right through to Roman Dutch law. Simply meaning you have South African law of contracts, and it has been developed from Roman law. Now, the South African legal system, it has three types of law. In this case, it's Roman law, common law, and then Roman Dutch law. So in this case, right, what are we saying? We are saying that the South African law of contracts, it has developed from Roman law. Okay, it has developed from Roman law. So simply meaning out of the three things, it has developed from Roman law, and then at a later stage, as it developed, the general concept of contract, it then evolved or developed or penetrated into what we would call Roman Dutch law. Now, when we now talk about Roman Dutch law, it simply means this is now where it was treated, what was treated, every agreement, where every agreement that was made, where it was treated seriously and deliberately as a contract. Why? Because of Roman Dutch law. That essentially is what that says. The law of contract, which forms part of the law of obligations. Woo! Now, the law of contract, which forms part of the law of obligations. It is based on the simple principle that one must honor their promises. It is essential for the smooth running of society that its members must keep their promises. And thus, the law of contract, which forms part of the law of obligations, thus the law of contract has been described as the endeavor of public authority to establish a positive sanction for the expectation of good faith, which has grown up in the mutual dealings of men of average right-mindedness. Okay, a building or a construction contract may be defined as a contract in terms of which one party, namely the builder or the contractor, agrees to perform construction or engineering work for another, okay? And this another, it normally refers to the client, otherwise known as the employer, who in turn normally undertakes to render counter performance in the form of payment of a sum of money. Just to give an example, with building contracts, many parties are involved, resulting in complex contractual relationships that require careful consideration. Thus, in any project, one might find the following parties present. Now we are going to deal with the parties present, okay? Number one, it is the client or the employer. Number two, it is the principal agent, in this case your engineer, okay? And then you have the contractor, the clerk of works, or your resident engineer. Then you have your subcontractors. This is obviously where applicable, okay? And then you have other prime contractors or consultants. Basically, these are individuals, agents, or entities that feed into the project. Yes. So now we move over to 6.2. 6.2, it deals with what we call obligations, the concept of contract and requirements for validity. Okay, not all agreements between persons are contracts. Only those agreements that create obligations are considered contracts. Okay, thus a contract is an agreement that creates obligations or legal ties. Now, what is a legal tie? A legal tie, it just basically means rights and duties between legal subjects. Okay, the obligation is a juristic. The obligation is a juristic tie or relationship, meaning the obligation, it is a juristic tie or a relationship that exists between the parties to the contract, and it entails a right to performance from one party and a corresponding duty on the other to perform. Simply meaning you have two parties where this one has to perform in order for this one to perform. This one performs in terms of work being done. This one is performing in terms of payment being made. Okay. Thus, we are dealing with a legal relationship between two or more legal subjects. Okay. Certain agreements are not contracts because the parties do not intend them to be so. Okay. So just because there's an agreement, it doesn't mean that it's a contract. I mean, this should be obvious, right? Now, such agreements are mere social agreements and have no legal consequences or legal repercussions, okay? At most, they create moral duties. And if one of the parties does not keep to the agreement, he or she cannot be forced to do so. Examples of such agreements are when two people agree to go to the theater together, or where colleagues agree to form a lift club to drive together to the office. Not all agreements between persons are contracts. Okay? In order to determine whether an agreement constitutes a valid contract, it is seen that an agreement will be a contract only if the parties intend to create a legal tie, meaning a legal obligation between them. And in addition, all other requirements that are prescribed in terms of law are met. These requirements, now, okay, look at it like this. You make an agreement, but then there are types of agreements where they result into what we call a legally binding contract. And then there are types of agreements where it's an agreement, but they are not legally binding, meaning there are no legal repercussions. Okay, so there's a distinction between agreements. And then that is what it means when it says here, in order to determine whether an agreement constitutes a valid contract, it is seen that an agreement will be a contract only, meaning there are conditions that result into what we call a contract, okay? Will be a contract only if the parties intend to create a legal tie or legal obligation, simply meaning they should intend. It speaks to intention, okay? Right, meaning both parties should intend for it to be a legal contract, okay? That's one of the things, or the key attribute to this. In addition, all other requirements that are prescribed in terms of law are met, simply meaning they should intend for this to be a legal contract, and it states here, the terms of law are met, meaning there should be a legal framework and they should operate from that legal framework, meaning it should be reasonable within the parameters of the law. That's how I interpret this to be. Now let's look at these requirements. These requirements are important. The parties must reach an agreement, otherwise known as a consensus. The parties must reach an agreement. They should agree, okay, who is going to do what, who is going to get paid how much. These are examples of an agreement, okay? That's number one. Number two, the parties must have the necessary contractual capacity regulated by the law of persons. They should have the necessary contractual capacity, okay? Now, what do we mean when we say this? You cannot go to someone who is not a builder and then you expect them to build you a house or to build you a building or whatever. Why? Because they lack the capacity, okay? So this is what we mean when we talk about capacity. When you want someone to perform in something which is outside of their capacity to perform, or in order to deliver, obviously now you're being unreasonable. When you are being unreasonable, that affects the validity of the contract, okay? Parties must have the necessary contractual capacity, simply meaning it's the same as you ask a 14-year-old child to sign a contract. I mean, come now, do they legally qualify? Do they have, legally speaking, the capacity to sign the contract? It's the same as someone who benefits from a contract, who signs as a witness. Do they have contractual capacity? Okay, that's what we mean when we talk about contractual capacity, or at least that's what comes to my mind. Okay, so these requirements are: the parties must reach an agreement, otherwise a consensus. The parties must have the necessary contractual capacity regulated by the law of persons, okay? And then also performance, that's number three. Performance must be certain or ascertainable. Here's an example. There must be certainty as to the obligations created by the contract. Performance must be certain or ascertainable, simply meaning there must be certainty as to the obligations created by the contract. If you draft a contract that basically says nothing, I mean, come now. If I hold you legally accountable, it's legally accountable for what? For nothing, meaning there is no contract. Okay, that's number three. Number four, performance must be possible at the time the contract is entered into. Performance must be possible at the time the contract is entered into. Number five, the conclusion of the contract. The performance and the objective of the contracting parties must be lawful. Again, the conclusion of the contract, the performance and the objective of the contracting parties must be lawful. Okay, and then that's number five. Now we move over to number six. Number six, it basically states the formalities required by the law must be complied with. The formalities required by the law must be complied with. And And that now brings us to the last point, point 7. The contract should be voluntarily and deliberately entered into for a reasonable cause. Simply meaning the contract should be voluntarily and deliberately entered into for a reasonable cause. Okay? The above requirements are absolute requirements. Okay? Thus, should any of these requirements be found to have not been met, the contract will be invalid. The above requirements are absolute requirements. Thus, should any of these requirements be found to have not been met, the contract will be invalid. Okay? Conversely, compliance with all the requirements must necessarily give rise to a valid contract. Now, here's an example. Roger offers to build a swimming pool for Claire at a cost of 45,000, and Claire accepts this offer. Presuming that all of the above requirements have been met, this would constitute a valid contract between the parties, in terms of which both parties will be bound by the contract and will be obliged to perform in accordance with it. Roger is obliged to build Claire a swimming pool, and Claire is in turn obliged to make payment in the amount of 45,000 rand to Roger.